Story time. Green card got denied because the petitioner did not meet the income requirement, necessary income requirement to sponsor someone. That's why it got denied based on public charge. Well, what exactly can you do? They should have done it when they receive a request for evidence to do their consultation, so we can advise them however they came after the fact, after the denial. Well, what's going on is that if you have somebody, you sponsor somebody, and your income is not enough, how do you know? You go on USCIS.gov, you look at poverty guidelines, household size, and income has to be above 125% of poverty guideline. It just gives you the income. And how do you know your income? You look at your tax return, gross adjusted income. Individually, you look at your W-2. If you are self-sponsor, you have to look at your Schedule C and look at your 1099 forms to know your individual income. And based on the household size and based on your income and the person you're sponsoring, you add all the number of the people that are depending on you to additionally the person you're sponsoring and the person that you've sponsored before. If they still have the green card, they're still under you. So then you will know exactly if the petitioner or the joint sponsor meet the income. Okay, those are things we can figure out easily by just asking you simple questions. That's why consultation is necessary, okay? Instead of just getting a green card denied for that. That was really a simple reason. And another way too, if you don't have a joint sponsor, that's what we did with one of our clients, because they've been working in the US for 10 years legally, because they have a work permit based on asylum pending. We went to the Social Security services and we got their letter that shows the 40 credits because they've been working for 10 years, right? And we added asset, meaning what? Money that they had in their checking account and saving account. And there's a way to calculate how to, in addition to the income of the sponsor or the joint sponsor, how to add those money. And all that is going to help you to show that you have asset, you have met the income requirement, and so that your green card can be approved. So this person came after the fact, but again, we advise them. We hope that they're going to file the form 290B because the green card has already been denied, but they can file the form 290B with all the evidence to show that the joint sponsor has met the requirement. And that's why they even ask for W-2, so they can see the individual income as well. So you have to show them everything sufficient enough for them to make a good decision on your behalf. Otherwise, green card is discretionary. Then USCIS, if they see that the income is not enough, they're just going to deny it, especially after they sent you the request for evidence. Another case got denied. That was a work permit because of the clock. The client says that they file after 150 days, but if you count it, pretty much it's not 150 days after the asylum was pending. But if you want to really be sure, we always advise that to wait for 180 days because the work permit has to be pending for 30 days after the 150 days, okay? So if you just wait for 180 days, 6 months, then you file for your work permit first time, and they will give it to you within 30 days of your filing. That's really simple in terms of not being sure of how many days have you wait. If you wait for 180 days, then the 150 days are included, and the 30 days of pending work permit has already been included. That way you know for sure that when you apply, you're going to get it within the 30 days of applying, instead of getting a denial just because you send it and they calculated it's like 149 days or something around those lines. So sometimes they can make a mistake too, in those calculations. But if you wait for 180 days, there's no way they can make a mistake, because you will say the 150 is already included. You see, because once they deny, then you're gonna have to file the form 290B. You're gonna send a letter to tell them it's their mistake. It's just gonna waste your time. If USCIS, the way they respond, it takes forever. So yeah, it's gonna just waste your time. That's my advice, really. That's how I do it, just to avoid those calculation mistakes. By the way, what's really going on in Texas? Well, again, as you know it, Texas has this law that says that the police can arrest immigrants who cross the border illegally and put them in jail for 6 months. That's for first-time offender. Up to 20 years, that's for second-time offender. And the second-time offender who can be charged with aggravated felony. Then everybody that has been arrested will be deported to Mexico, even if they are not from Mexico. And that law gives the judge the power and authority to do so. Well, that law really has been in debate. And recently, the U.S. Supreme Court decided that the law should take effect because it was suspended. It was supposed to take effect in March. On March 5th, it was suspended. Then the Supreme Court gave them the power. And now, but they remanded back to the lower court for a determination. And now the lower court, Texas, is struggling to make an argument on how they plan to arrest migrants. So that law is still suspended, at least for now, as of today, early, right? I don't know what's happening right now. You still have to keep checking. But I will continue to check the story, follow the story. That's why you should subscribe to my channel, so you will be updated on anything. And if it's a matter of leaving the state, because really those laws are not for you. If I'm in that position, to be honest, I'm just gonna move to a different state, because I don't want to be dealing with some places where anytime I can be arrested and deported to Mexico. I'm black, I'm not from there. So yeah, you know what I mean? So that's just my opinion, honest opinion. So if I'm in that position, I mean, if I have to move, I have to move. I will, because I don't know tonight if the law is gonna go back to effect again, because it's right now there's some suspension on it until the lower court they come with a decision, until Texas. But Texas is struggling really with the argument. Anyway, if you need a consultation, which is highly recommended. Why? Because we can properly advise on your case. At least you have an idea, some clarity. Even if you just need a second opinion from somebody else, you should schedule it, okay? By using the consultation link in the description box below. By the way, the Dolly memo is still going on. If you have a case that you're trying to reopen, this is the time to do it. We have been successful, at least we can say it, reopening cases, old deportation cases. If the person is prima facie eligible to adjust, we can make that argument with ICE. We can use the Dolly memo. We can reopen those cases so that the person can adjust status with USCIS. This is what we do best. Call us, schedule a consultation. Until next time, bye-bye.